It's my pleasure as President to welcome you to this, the 2013 Conference of Council. In no particular order, I'd like to acknowledge the presence at this conference of Annette Bradfield, President of the Queensland Law Society, Martin Hagan, Acting Secretary-General of the Law Council of Australia, Fiona McLeod SC, Chair of the Victorian Bar, Michael Tidwell, CEO of the New South Wales Law Society, past LIV Presidents, Council Members, Suburban and Country Law Association Presidents, Section Chairs, our CEO and members of the LIV Leadership Group. I'd also like to acknowledge the traditional owners of the lands on which we meet, the Dja Dja Wurrung people of the Kulin Nation, and offer my respects to their elders past and present. As a profession, we need to embrace change and diversity if we are to respond to what is a dynamic and evolving legal profession. If we don't, we risk being relegated to history like the lamplighters. In recent years, we have witnessed some fundamental changes in the law and the way it's practiced. We've seen brand name Australian firms absorbed by US and UK firms. We've seen many firms incorporate and even list on the stock exchange. And we have seen firms adopting outsourcing and delegating tasks such as discovery and due diligence to companies in India and other low-cost jurisdictions. All of this would have been completely unthinkable at the time I started practice in the early 1990s. I would like to briefly recount my wake-up call on the need for us to change and adapt, and to do so urgently. At the height of the mining boom, the then LIV President, CEO and I visited one of the large law firms to meet with its management partner. In commenting on the various offices of his firm, he said that he saw a good growth story for his Brisbane and Perth offices, and the need to maintain strong Sydney presence given its role as Australia's financial centre. But what really alarmed me was his observation that he couldn't see where any growth would come from for his Melbourne office. That long-standing Australian firm no longer exists as an Australian brand, and its partners report to management in London. I expect they are even less likely to understand what's going on here in Victoria. You might counter that this is just a large firm view, not relevant to the many small practices that make up a large part of our membership. However, I think you'd be wrong. We only need to look at the experience in the United Kingdom, where recent regulatory reform has given rise to the real prospect of Tesco law, that is, legal services provided in your supermarket, to realise that the forces of change in the legal profession affect us all. We could fight such changes by imposing and maintaining barriers, but I think that's the wrong approach. Instead, we need to embrace it and adapt ourselves. I'm the first LIV President with an Asian background. Therefore, it seems obvious to me that part of the solution is to engage better with the region, where much of the world's economic growth is predicted to be generated in the coming decades. However, to do this, we need to broaden diversity within the profession, which unfortunately remains predominantly comprised of men who by and large share the same or similar cultural and educational backgrounds, particularly so at the upper echelons. While the battle on gender is by no means complete, the discussion does need to be expanded to include culture and other elements of diversity. In our first session of the conference today, we'll focus on the issue of diversity in the profession, covering culture, gender, sexual orientation and disability, among others, and the barriers to broader participation. This will include a discussion on the issues of stereotype threat and implicit bias that can exist as hidden barriers to progress on this front. This includes the so-called glass ceiling, if you happen to be a woman, or the bamboo ceiling, if like me, you're a person of Asian origin. I became more aware of this phenomenon after attending an American Bar Association conference last year. It highlighted a number of studies which have been conducted that evidence the existence of such biases. This session on diversity will be followed by a discussion of how the profession should respond to the Asian Century White Paper released by the federal government late last year. That paper suggests that by 2025, the region as a whole will account for almost half the world's output, and it will be the world's largest producer of goods and services and the world's largest consumer of them. To take advantage of that, the paper indicates that Australians need an evolving set of Asia-relevant capabilities that are both broad and specialised. We, as a profession, need to develop such capabilities to ensure that we can grow into Asia with our clients. We also need to find new ways to practice. It seems to me that the general practitioner will be under threat on a number of fronts, and to compete will need to specialise and find their niche. This is a sweet spot where a premium is paid for bespoke legal services that Richard Susskind identified in his seminal book, controversially entitled The End of Lawyers. But given that legal problems are rarely confined to one area of law, we also need to develop the capability to come together in a more flexible manner to solve our clients' issues. And we need to do so in a way that accommodates a diverse profession, particularly those who have the skills and experience, but don't or may not even want to work full-time in a traditional office environment. This afternoon, we will hear Dr. George Beaton's perspectives on what the legal landscape will look like in 2020 and his insights on potential avenues for innovation. This will be followed by a panel discussion in our first session tomorrow on emerging models of legal practice, with a view to understanding what small firms must change in order for them to both survive and to prosper. And I believe all of this change needs to be accommodated in a manner that reduces national and ideally international barriers to movement of lawyers and minimises the associated regulatory burdens and costs. The division of the Australian legal profession into separately regulated state markets, each with their own idiosyncrasies, made perfect sense in the early days of federation. However, it is completely inconsistent with modern-day practice, where you can provide advice from anywhere in the world with Wi-Fi or mobile access. Many would say that the proposed national legal profession reforms were flawed from the start. This is because, while they addressed some of the barriers, they would actually increase the regulatory costs. I remain hopeful, however, that the pared-down model profession reforms to initially apply in Victoria and New South Wales can be structured in such a way to demonstrate that the benefits can be achieved at minimal cost, and we can convince other states and territories to join the scheme in due course. It should be possible. As a tax lawyer, it annoys me that the accountants with whom I work or compete can arrange an effective national professional standards scheme, while the protection of lawyers seemingly depends on the state or territory in which they happen to operate. In addition to addressing these key themes, we will launch the results of our recent survey of members, which provides some interesting data on what our membership looks like and what our members want from the Law Institute. We will also learn about the proposed social media campaign that will be launched in 2013 to enhance the reputation of lawyers. We will gain insights from Rob Powells, as our former Attorney General, on what it takes to be effective in lobbying government. And by way of his version of Three Steak Knives, he's going to throw in his views about alternative billing models. And we will hear Martin Pakula's perspectives on the government's tough-on-crime policies and their interaction with the Charter of Human Rights, as well as his views on the current legal aid crisis, an issue which is vexing a lot of us. Ultimately, the future of the legal profession is not about us. We are merely custodians for the recent graduates and the law students working their way through the system who represent the future. Our challenge, therefore, is to leave the profession in a better state than when we started. I have been fortunate to come away from each of the past conferences of council that I have attended, challenged and inspired by the discussion and bursting with a range of ideas to take forward. I hope that each of you will feel the same at the end of this conference. As outlined in your conference program, we will be relying on each of you to communicate the outcomes of the conference to your sections, law associations and wider networks. we will provide each of you with a summary of the themes and issues discussed for this purpose. And finally, some thanks and acknowledgements. Firstly, I would like to thank our Council Secretary, Jodie Cooley, for bringing my vision to fruition in terms of the fabulous content and speakers at this conference. I'd also like to acknowledge the work and dedication of Kerry O'Shea, our Public Affairs Manager. Unfortunately, she cannot be with us here today, but she has been a stalwart in the Institute's successful engagement with the media over the last 5 years, leading the way on the Bushfire Legal Help Service, taking it to government with the Smart Justice for Youth initiative, and most recently with the legal aid crisis in Victoria. Regrettably for us, she will be leaving us to take on a media role at the County Court. I guess we can at least look forward to some entertaining tweets coming this way from Chief Judge Rosines. That's all for my introduction, so thank you.